There we go. How's that? Is that better? What up? How are you guys doing? Hold the line. Let me make this bigger. There we go. Now I can see the sweet. Yeah, sorry I was muted. Um, yeah, I'm doing a document review. Let me ping the Discord real quick. And then I actually won't be playing Aram, so that document reviews or that thumbnail's a little misleading, but whatever. Um, where else? I'll save that. What up, Jinx? Radicy, Bobby, Brian, Connor, Karen, and hey, thanks guys. Thanks for joining. What up, Solo Bard? Hold the line. Is that you, Ash? Um, yeah. What up, everybody? Legacy, just Joshin, Row. Yeah, thanks for coming. Hold the line. I'm going to be reading these documents. Just going through them live and then kind of taking some notes. Actually, I might not take notes because I just have this video and then I'll just review it when I'm making the new one. Yeah, thanks for stopping by, Bobby. You have a good day. You going to work or heading out or what? What up, Ryan? 6 days a week, dude. How you doing? So wholesome. I'm in my 30s. I guess that doesn't really necessarily make me wholesome, but uh, yeah, I guess it might be because I'm a little older. Parkour gym? That's rad, actually. I would bust myself up. My knees are so jacked. I used to skateboard, and I had to have, I tore a ligament in my knee, my hip, or tore a ligament in my knee, my ankle, had nerve damage in my hip, and had a concussion. So I can't do shit like that anymore. I'm not sure what the moldy bread is for. The moldy bread and the maggots and stuff. In my opinion, I think it's either for selling to the goblin merchant, maybe crafting, or maybe quests, because I know that they were going to implement quests. Um, Somebody said it might be like spell reagents, but I'm not sure. I really have no idea, but I think it's going to be. My assumption is that you're going to sell it to the the gobbo. Also, how is this camera angle? I don't know. I know that you can only see like half my face, but um, I had it above my monitor. Now I have it off to the side, so I might be able to like move it over a little bit. That should be a little bit better. Um, Derp is totally wholesome and looks like a Greek sculpture. Thanks, Django. I'm built like like a 5'11", like 6 foot tall dwarf. My funny story, the I was at a wedding and I was going to go buy a shirt and I have to get shirts I have to get shirts from specific places because my neck is so big. Like the dude I went to, I left my shirt at home, my fancy shirt for the wedding, and the guy went to go measure my neck to fit the shirt, and he was like, "Sir, we don't have any shirts that'll fit you in stock because your neck is too large." And my girlfriend was like, "Yeah, he's built like a dwarf," just like super loud in the middle of the store. It's pretty funny. Um, but yeah, let's get to the document. It's hot as heck in my room, but I'm too lazy to go get my AC. Um, So this is the plaintiff's opposition to the motion to dismiss on grounds of form non-convenience. Basically, this is Nexon saying, "Hey, we object, to the dismissal," and this is why this is their reasoning for their objection, and why they're sending it, like why they're opposing it. It's their opposition letter to the court. So, um, it's 35 pages. I'm gonna skim through it. I think I have like an hour and a half, and then until I have to go, I have to run to the store. I jumped on a little bit later than I was planning because I forgot to eat, so I had to cook food. And I've been running a few errands. But yeah, let's get right into it. So I'm going to skip this stuff, and I think there's some stuff at the end that I can skip to. I kind of skimmed through it. So a lot of this stuff is their citations, which they have a lot of citations, obviously. So the case citations. So there's like 2 or 3 pages of case citations, and they do this Sandstrom or Sunstrand case they cite a few times, and then there's another one in here that they cite a few times. Yeah, the pension fund they cite more than once, and then there's a third one. Yeah, I think it's this one, Creative Tech Ltd. They cite 3 times. Atlantic Marine's been cited by both a few times, and then Baltimore and Ohio versus Kepner. But yeah, so I'm gonna look into these cases specifically, but I'm not gonna do that today. I'm gonna do it for the video because I want to know what they're citing. I want to know the ins and outs of those cases. But they cited a lot of stuff. For me to go through all of these cases and dig into each one that they cite would be an astronomical amount of time. So I'm probably just going to go into the ones that they cite the most, and then maybe skim the rest and just kind of get a quick synopsis. And then, so the introduction is basically just them going over the case and who they are, right? What up, Mike? Talented guy, Phantom, Burn, Eagle, Mr. Boombastic. That's a great name. Yeah, thanks for joining. Thanks for watching. I haven't really gone over anything. I'm just getting into it. I have about an hour and a half, so I'm going to try to read through this pretty quickly. It is 35 pages. And I have to Alt-Tab to check the chat. So, beginning in August 2022, defendant Iron Mace Company Limited, Iron Mace, Mr. Choi, and Terrence Park, collectively the defendants, conducted a series of playtests in the United States of an English language video game entitled Darker Darker. Defendants placed the game on Steam, an online platform operated in Washington-based Valve Corporation, relied on servers of Amazon Web Services to host online gameplay, and internationally targeted the United States market, including by heavily promoting the game in English on the United States-based internet platform Discord, Twitter, YouTube. Defendants targeting the United States was successful, with a substantial percentage of Dark and Darker's player base being located in the United States. Korean gamers, on the other hand, could not play the game during the defendant's 5th playtest and last playtest of the Dark and Darker because defendants geo-blocked them. That's pretty funny. Defendant's activities violates Nexon's United States copyright and trade secrets rights. This copyrights part is really only even being included at this point because of the DMCA. In a video game project entitled P3, Docket 1, Defendant does not contest. The defendants do not contest that Nexon states federal claims against them that fall squarely within the court's jurisdictions, having failed to seek dismissal for failure to state a claim or for lack of subject matter or personal jurisdiction. Defendants nevertheless contend that the court should dismiss this action on forum nonconvenience ground and require Nexon to bring its federal copyright and trade secrets claims in Korea. Defendants are incorrect. As the Ninth Circuit recently held, copyright cases considering alleged unlawful activities purposely directed towards the United States are more amenable to suit in the United States than in defendants' home territory. Lang Van Inc. So this is one that I'm going to have to look into pretty heavily. Having targeted the United States with their unlawful activities, defendants must now defend their actions in a United States court. So, I see what they're trying to get at. I don't know how well this will hold up, because a large majority of the business that they're doing is in the United States. Nexon feels that Iron Mace should have to defend themselves in the United States because it's affecting the marketplace of the United States, right? And U.S. consumers. So, I get it. It's a valid point, but it's I have to talk to some people, like my friends who are lawyers, before I completely make up my mind. But just off the top of my head and like my basic opinion, I don't really think that's a strong argument. Because I think Nexon's, I mean, they're both based in Korea. Both companies are based in Korea, and where, like the principle of the case, none of the illegalities of the case or trade secrets are from the United States. Nothing that actually transpired other than the distribution method and the marketing, the targeting of the marketing happened in the United States. The crimes or the alleged crimes that happened, or the alleged wrongdoing that happened, none of it was based in the United States, just distributed. So they're arguing about crimes that are illegal in the United States that happened somewhere else. You're not going to get tried for. So say you stole something, like you physically went to Korea and you stole a TV, and then you went back to the United States and sold it. Where are you going to be charged and for what? Now, if the case was purely distributing the copyrighted product and profiting off of it, I would say the United States. So if you're going to try strictly the sales of the TV, like selling illegal goods, it's a crime. So if you're going to charge them for the selling of the illegal goods, that would be done in the United States. But you would charge for the theft in Korea. So there was no trade secrets actually stolen or repurposed in the United States. All of that actually happened in Korea. So I don't know how strong of an argument this is. I would have to talk to a lawyer. But to me, it kind of makes sense that you would separate the sales. So, like, to me, it would seem like they have if the copyright's hold up, then they have a copyright case in the United States. But the trade secret theft didn't actually happen here. So why are we trying the trade secrets theft in the United States? It's kind of a waste of time and money, because it's already being handled in Korea. So why? That doesn't make sense to me. What up, DK? Thanks, Mr. Bombastic. Yeah, 1K. Honestly, I'm gonna make a video about it. But now that I'm like on a new page, I'm gonna take a minute to kind of address this. I have no idea uh, what to say, or to be perfectly honest, I know it might not seem like a huge deal to a lot of people, um, but reaching 1K subs was something I never really thought would happen. It was something I never was really trying to do until, I saw people watching my videos and like making this dark and darker content really kind of, not only do I like doing this kind of stuff, I would be doing this anyway, so might as well record myself doing it and put it on the internet. Because it's of interest to me and some of my friends. But like my intention was never to like make a bunch of money from YouTube, or really make. I didn't know if I would make any money, especially like this quickly. Um, and I still haven't. I haven't even met the $100 threshold to withdraw any money from YouTube. They won't send me a check until I reach $100 and add conversion and supers and all that stuff. So it's still all locked away by YouTube. I haven't made a single penny from it. But the fact that I'm able to monetize now, and the fact that I'm now able to show ads on my content and make a little bit of the money back that I've been spending on these documents, because I think I spent like $15 last night on just the few documents I got. Um, and I have like, I think a when I compressed the folder, it was like 55 megabytes of PDFs compressed. So it's pretty like probably like 40 PDFs for this court case, and I'm just now starting to make a little bit of the money back, but that's kind of beyond the point. It's not really about the money. It's about like what this is doing for me, um, and in my life, which is huge. It's like completely re-energized my drive to do something creative. I'm an author, but I also, hey bird, I'm an author. Creativity is in my blood. Um, but that passion to do like writing and even my game dev stuff and creating content kind of started to die for a little bit because my life has been honestly super crazy. Um, and hitting like 500 subs and seeing a few thousand people watch my video has really reinvigorated that spark in my creativity and my drive to really want to keep doing this stuff and write my books again, and um, get back into game dev, like work on my project, create more videos. This community is just completely changing my life, and it's insane. So I wanted to say thank you guys. I'm gonna make a video about it, but we're here live, so um, I really do appreciate each and every one of you guys. You guys mean the world to me. I couldn't do this without the support of the community. You guys make this happen, and I just can't say it enough. Thank you guys. You guys are crazy. Like, you guys are crazy, and I love you. Hey, bird. Sorry. Oh, you want to hunt birds? Come on. Sorry, I gotta open the window. It's gonna be a little bit bright. There you go, bird. Thanks, Dragon. Thanks for stopping in, Dragon Dave. Talented guy. Um, yeah, thanks everybody. But yeah, I'm gonna make a video about it. Um, it's like this is pretty much like kind of life changing for me, and I just really appreciate what this community's done, and it's crazy, and I love it, and I love you guys. You guys are rad. But I'm gonna get back, and I don't want to get all sappy and spend the next hour talking about it. Um, but yeah, let's get back into it. So what they're saying in this page is basically most of the business is done in the United States, so we should try this in the United States. Um, I think that's kind of BS because none of the criminal intent didn't happen here, except for like the sales and distribution of the stolen goods. Um, the theft of that stuff actually happened in Korea. So in my opinion, this doesn't really hold a lot of water because they're arguing that the crime happened in the United States, but it didn't. The trade secrets part of it actually happened in Korea, and the sales and distribution part of it happened in the United States. So there's a pretty big distinction. Um, but they're suing for both trade secrets and copyright in both the United States and in Korea. If they were suing for just copyrights in the United States and just trade secrets in Korea, that page would have made a lot more sense to me. But right now, it just seems like they're trying to double up on the court cases, which is an abuse of power, really, and financial means. So they're also arguing that a form of non-convenience dismissal as sought by defendants is an exceptional tool to be employed sparingly, in which a defendant must make a clear showing of facts which establish such oppression and vexation of a defendant as to be out of proportion to plaintiff's convenience. I mean, they kind of can. Iron Mace can say that Nexon has a lot more money to fight two cases at once, especially in the United States, because they have Nexon US. There's a United States branch of Nexon. So it is way easier for Nexon to fight this case because they have a US branch and they have a lot more money. So this argument doesn't really hold up, in my opinion. Kind of that might bite them in the ass. While the standard should not be misunderstood as one that compels plaintiffs to choose the optimal forum for their claim, the United States is the optimal forum for Nexon's United States claims, not an oppressive or vexatious one. So they're trying to say that Korea is oppressive or vexatious. Indeed, Korea is not an adequate forum where a plaintiff's right to obtain relief in a forum is a mirage in light of the foreign court's procedural rules. The foreign court is inadequate. So then they cite Beijing Science and Technology versus iTalk Globe Communications. So iTalk Global Communications. Okay. Defendant's central defense is that they are independently created rather than copied Dark and Darker, but Korean courts are powerless to compel production of the source codes that runs Dark and Darker, and defendants have refused to produce it in Korea, leaving Nexon with only a mirage of remedy on important parts of its claims in Korea. That's false. So that's objectively, that's what I like to call obfuscation. They have rejected to produce the source code for Dark and Darker to Nexon, but they did already give it to a third-party investigator. They just haven't given it to Nexon to look over themselves. So this whole part is pretty much obfuscation. This paragraph is basically wrong. And the whole page above it is kind of arguing against their own case. So far, there's not a lot of this. Like, they're all they're all statements, right? They're all statements that make sense, that have merit. However, if you put them all together, it doesn't really hold any water, at least so far in my opinion, and we're only on page 2. Nor have defendants submitted any evidence in the forum identified in the forum section clause upon which they rely sole central district court is available. Rather, defendants have represented this to this court only that they are amenable to services of process in Suwon, not Seoul. And in the Korean litigation, defendants have stated that Seoul court lacks jurisdiction over the merits. So Iron Mace is trying to have all of this stuff processed in the court that is documented as per their contract. The one that is actually by Nexon headquarters and Iron Mace headquarters, coincidentally. Furthermore, the private and public interest factors in the United States over Korea, that is true. Um, 40 something percent of their player of Dark and Darkest player base is in the United States, so a large majority of it. With respect to the private interest factors, this court has the full power of federal rules to permit Nexon and defendants to gain access to proof from others' files and witnesses, while Korea has no pre-trial discovery process. I did not know that Korea doesn't have a pre-trial discovery. I mean, kind of makes sense, but that's also not. The judge has already requested information, and it has already, to the best of my knowledge, received information, and the investigation is going to be done on the 19th. So it's not really called discovery, but they still have the ability to gain evidence and information. Moreover, the third parties with information relevant to this case are located in the United States, making this court like who? What third parties with the relevant information? Are they talking about AWS and Steam? Sorry. Making this court a superior forum to Korean court. So because Steam and Valve, or because Valve and AWS are located in the United States and Washington, um, I mean, kind of. So my question to then would be: is Nexon planning to call Steam and AWS in uh, as witnesses? Are they calling them to come in as witnesses? Like, what's their plan here? PB and Jams, I haven't seen it. Um, he mistake. That's hilarious. Thanks, Vivez. Um, yeah, I try not to hide who I am or like how I feel. So I'm just gonna be truthful and honest. And you know, to me, I've held communication as like one of the core principles in my life, and it's just how you communicate to people is important, and um, being truthful and honest with yourself and them is super important to me. So yeah, thank you. Full Dark and Dark Saga is the same. Yeah, I mean, really, this whole thing is kind of like I really just want to make content, whether it be books, video games. I got a Huan art tablet to start drawing again. I used to do graphic design um, for a little bit in college, but yeah, I've just like this whole thing like has kind of just reinvigorated that spark and creativity. It's crazy. Um, Essays 29. I played fighter a lot in groups. Um, I did like tanky fighter, like PvE fighter, and then I would have a spear or longsword as my backup for PvP. So I would have like a big shield and then usually like a falchion in full plate, and then I would use that for PvE. And then if we got engaged upon in PvP, I'd switch to longsword or spear. I also played in duos. I had a partner that we would go cleric cleric. I would go healer cleric, and he would go offensive cleric. So that was like ultra fast room clear. It was great. Um, but solo, I played mostly bard, or I did play a lot of bard as well. Um, and I played bard mostly either in three man group, solo, or if I was solo, my three classes were like ranger, rogue, or uh, I mean fighter, rogue, or bard. I played ranger at first a lot, but I kind of switched over into the two hand. The I would do longsword or spear as my secondary, and then I would do two dual wield fighter as my solo. It just wrecks. Sprint with light armor on, like cloth and leather, plus the attack speed bonuses and stuff that you get. It's just insane. Yeah, Warmaul cleric. That was like my buddy Sugar Boots. He would go like attack cleric, and I would go heal cleric, and we would do duos, and just nobody would be able to kill us ever. Ranger does need a quiver. Just stack all the arrows into one giant stack and make it a quiver icon. Yeah, PB and James, I plan on covering a lot of stuff. I want to cover like the death of the cycle. I'm gonna probably cover a lot of um, Baldur's Gate 3 stuff because I've been into Baldur's Gate since Baldur's Gate 1. Um, I might get into Diablo 4. I'm gonna do Halls of Torment, but I also do want to cover like other gaming news, like lawsuits and other stuff like that happens, and like why this kind of stuff happens in the gaming industry, because I think a lot of the stuff in the gaming industry happens behind closed doors, and it kind of hurts the consumer more than it helps. Um, but yeah, yeah, I've had Baldur's Gate 3 early access since the day it launched. I actually got it. I got like a sneak peek. I used to work for um, gaming companies, helping set up booths at like PAX West, and I would like take their shipments, and some of the people that do like from Europe that would come over and do like PAX would stay at my house. I have buddies who worked for CoatSync, so I'd help them out, and I get to go in early, and I get in for free and all that stuff, and um, help do like setup and networking and marketing and stuff. But I got to play Baldur's Gate 3 a little early. It's pretty rad. The Larian guys are really cool. So, with respect to the public interest factors, the Ninth Circuit Court has instructed that a defendant's targeting in the United States favors resolution of plaintiff's claim under the United States Lang Van because the defendant geo-blocked Korean users and targeted the United States as their primary market. The public interest strongly favors resolving Nexon's claims of infringement and misappropriation in the United States in the United States court rather than Korea. So they're going to hammer this in a lot. But we are already, again, they stole the TV in Korea and sold it in the United States, right? So which one do you try? In the United States, you would try the sales, so the copyright issue, not the trade secrets. In Korea, they didn't sell anything in Korea in Playtest 5 because they geo-blocked it. So they wouldn't do the copyright, they would do the trade secrets in Korea. So they kind of, but Nexon combined both in both Korea, United States and in Korea. So there is an argument to be made that this kind of isn't really super valid, and them bringing it up a bunch of times kind of just reiterates the fact that uh, no matter how many times they cite the same source, it doesn't really change the fact that they're trying somebody, or they're trying a group of people for the same exact cases twice. So one of the cases pretty much either has to go or has to change, right? Or they have to change to better fit the actual crimes. So like a judge might dismiss the trade secrets part of this in the United States, but let the copyright go through. In which case, Nexon have a very weak case in the United States because the copyright they use completely different assets, right? So it goes from less about being a trade secrets case in the United States and more about copyright because that's where all the sales went down. And then it goes to a trade secrets case in Korea, but that case carries like a criminal fine and criminal penalty more than something that would be disruptive to their business. So it's iffy, and I want to talk to my lawyer friends about this because before I make like a solid statement, because I don't know how that's going to play out. I don't think off the top of my head that them trying that angle plays out in Nexon's favor. With the presumption and weight of the forum non-convenience factors overwhelmingly against them, defendants rely heavily on forum selection clauses in Choi's and Park's employment-related agreement, with Nexon calling for certain disputes to be litigated in Seoul. But as explained by Professor Suk, these clauses do not encompass disputes based on post-employment tortious conduct. So what they're saying is that this is hilarious. These clauses do not encompass disputes based on post-employment. So basically post-employment legal cases. So right here, they're basically arguing under the penalty of perjury that the case doesn't hold water anymore after the termination of contract. So that's the that could be huge. I'll have to look at their contract again. But it could negate the non-compete. So that means that if according to Nexon these clauses don't carry over until they don't carry over after termination, then the non-compete's thrown out the window. The protection for their IP is mostly thrown out the window. A lot of that stuff is thrown out the window because the contracts they don't hold any water anymore. But I want to see if they try to get around that, because they might just say referring to these specific clauses, you know. But if they're going to throw part of the document out, then they could then Iron Mace can make the argument that the rest of it doesn't hold water either, right? So this might be a smart play, even if just the contract gets thrown out as evidence. That's actually pretty huge. So, moreover, the type of forum selection clauses at issue has been authoritatively constructed by the Korean Supreme Court and not reflecting an agreement to limit the filing of a lawsuit in Korea outside of Korea, or in a court outside of Korea. Sorry, I'm a little tired. Additionally, Iron Mace cannot rely on these arguments because it's not a signatory whose unlawful conduct had nothing to do with their performance. AMA Multimedia. Notably, defendants themselves do not believe the forum selection clause governed this dispute. When Iron Mace sued Nexon in Korea, it sued in the Suwon Court District, not Seoul, and defendants repeatedly argue Seoul Central District Court lacked jurisdiction. That's pretty damaging, if true. But when Iron Mace sued Nexon, they did so on something completely that they. So Iron Mace is the suit in Korea. The initial suit in Korea is actually Iron Mace suing Nexon to have them stop interfering with their business in the United States and in Korea. That lawsuit happened in Suwon because that's where Iron Mace is from. So they picked the closest court to their house. That's where Iron Mace is located. That's where they are located physically, where they reside. So it just makes sense to have it done there. But if Iron Mace said no, or if Nexon said no, we have to do this in Seoul because of your contracts, and Iron Mace said, well, I don't want to do it in Seoul because of this, and this, and then had that contract kind of thrown out, they can't then go and argue like Seoul is the perfect place to argue this, and it doesn't really make sense. But this is all just kind of hearsay from Korea or from Nexon. They are swearing it under penalty of perjury, so I don't think they would lie about this. But they're also not giving us exactly what they said. There's no quotations or cited articles here. So we don't know exactly what they said. They just argued against Seoul Central District Court having jurisdiction over Iron Mace versus Nexon. So, which it might have. Principles of court interpretation and judicial estapel do not permit the court to reward defendants for telling the court at sole exclusive jurisdiction to hear the dispute, while they simultaneously tell the court in Suwon that the sole court lacks jurisdiction. So repeat the same thing. Hold on, I will be right back. I think. Yep, Birdie scratched my leg and I'm bleeding. I will be right back. I am back. Sorry about that. Good cat. Yeah, she scratched my leg and like right on the shin. Trying to get my attention. And I just like put my hand down there to check it, and it was just like gross blood all over my fingers. So where was I? While there is no agreement requiring Nexon to bring this suit in Seoul, Iron Mace has agreed to litigate the dispute in the Western District of Washington. They had to. So I'll get into it after I finish the paragraph. In exchange for the privileges of invoking the DMCA counter notification procedure to pressure Valve to put Dark and Darker on its platform, Iron Mace stated that Iron Mace consents to the jurisdiction of the Western District of Washington. Congress required Iron Mace to make that statement to take advantage of the DMCA counter to notification process. Yes, of course. Iron Mace had to counter the DMCA, otherwise they would be forfeit. Congress' determination that this jurisdiction is an appropriate venue to sue foreign defendants that avails itself of the DMCA protections renders a judicial doctrine of forum nonconvenience unavailable as a basis of dismissal. Halliburton? Nice. Birdie just opened the door. And then they're citing Zipfel versus Halliburton. These guys, dude. Amended on other grounds by Articles 861F to D 565th 9th Circuit 1988. Defendants okay, so what they're basically saying here is that without the contract, there's no agreement requiring Nexon to bring this lawsuit in Seoul, and that Iron Mace agreed to dispute this case in the Western District of Washington when they responded to the DMCA. However, all of this is true, but it is, again, an obfuscation of the truth. The truth is that Iron Mace or Nexon filed the DMCA in the US and had them removed from Steam, right? Shortly after, I think it was like the next day, or like 2 days after that, Iron Mace filed the lawsuit in Korea against Nexon to have them stop DMCAing them, to get them to stop messing with Iron Mace, to get Nexon to stop. And that happened a few days later. Now, because of the way that this works, is the Korean, so Nexon has longer to reply to Iron Mace's lawsuit than Nexon has longer to reply to Iron Mace's lawsuit than Iron Mace has to reply to the DMCA. So all Nexon had to do was wait for Iron Mace to respond to the DMCA on the last final day, and then a few days later respond to the lawsuit in Korea. So there wasn't any ongoing lawsuit in Korea until after the DMC was actually accepted, because there literally couldn't have been, because Nexon didn't accept. The case had already been filed, but neither party had accepted it, and it hadn't been going forward. And Nexon didn't have any kind of countersuit at that time. Nexon didn't have any countersuit at that time to be used against them. So this is a super smart play by Nexon, but a judge is going to be able to pretty easily tell that timeline. Like, oh, hey, they had to accept this, otherwise they lose immediately, and you guys didn't reply until 2 days after the deadline for the DMCA. So they were stuck between a rock and a hard place. Of course they couldn't. There wasn't a. Of course they signed the agreement to the DMCA, or the counter to the DMCA. And some of this is just opinion. And then this Halliburton case, if it's the one I'm thinking of, is pretty funny. Halliburton's been involved in a few pretty high-profile lawsuits over the years. Defendants purposely targeted the United States and this district to violate United States copyright and trade secret law. This is opinion. Both of these. All of this is opinion. Also, they didn't violate trade secrets laws. They violated Korean trade secrets law. They didn't steal anything. They didn't steal anything, or aren't being accused of stealing anything in the United States. There's no U.S. trade secrets being violated. It's all Korean. And this district court is the only forum that Iron Mace has agreed is the appropriate one for resolving parties' dispute. For these reasons, the court should deny defendant's motion. I'm going to check comments real quick. Oh, damn. Yeah, Brick. That sucks. Dog bites are terrible. I thought from watching the Heard vs. Depp case, the U.S. court doesn't have to take into consideration even a ruling from another country. It depends on so Big Daddy Bubbles, it really depends on the situation and what they're arguing. Yeah, Cody, that's true. Iron Mace's dispute with Nexon isn't employment related. It's a business interference. This filing is that they argue against venue changes because they say the U.S. discovery system is better, suggesting they need it. But without discovery, how do they know it's stolen? Long live Iron Mace, now evil Nexon. Yeah, I'm completely on board with that. I started calling Nexon Evil Corp when I'm explaining the court case to my girlfriend. It's Iron Mace, the good guys, versus Nexon Evil Corp. So, background: Nexon is a video game developer. His subsidiaries and related company employ hundreds of people in the United States and conduct significant business here. according to the Huang Declaration, Nexon formally employed defendants Park, a United States citizen, so he has dual citizenship, and they leave that out. He's actually Korean and U.S. citizen. But he spends his primary citizenship is in Korea now because his residence is there. He has a residence in the United States, I think. I can't remember where, but it's like a rental or vacation home or something. And Choi to develop a video game under the project title P3. Okay, so we already know this. Consistent with industry practice and inherent limitations of standard computer programming languages, the P3 project source code is in English. During their employment, Choi and Park entered into agreements with Nexon calling for disputes with respect to agreements to be litigated in Seoul Central District Court. I never thought of that. Most, if not all, programming languages are in English, right? How does somebody that doesn't know English write? Is there like a way to translate the code? Am I dumb? Oh, Terrence might have sold it. I know that at one point he did own property over here. He might have sold his house. Without authorization, Choi transferred source code to other confident, or he might not own it anymore. But he does have dual citizenship, and I'm pretty sure he owned property over here at one point. Without authorization, Choi transferred source code, another confidential P3 project, materials to his personal servers between December 2020 and June 2021. During this time, Choi told Nexon employees he had secured funding for a new company, and he solicited employees to leave Nexon to develop a game similar to P3. After Nexon, so there's nothing wrong with making a similar title. After Nexon learned of Choi's solicitation, it audited Choi and discovered his unauthorized transfers. While Choi initially agreed to provide his servers to permit, so they do admit that they didn't investigate his servers until after they found out that he was leaving. So they found out that he was leaving and then made a big hissy fit about the servers. They admit it right here. So while Choi initially agreed to provide his servers to permit Nexon and conduct a forensic audit, Choi took back his agreement and told Nexon he deleted all the data. They leave out that he did so under advice of a lawyer, and that they also leave out more obfuscation. They leave out that as their employment contract directed, he deleted all of his stuff because he was told to in his contract, and his lawyer told him to follow the contract. Nexon terminated Choi on July 21st. Okay, so this is the first time we actually get a firing date, and it was the end of July. After approximately half of the P3 team left Nexon, including Park, Nexon temporarily suspended P3 on August 18th, 2021. Temporarily, no, okay, so they've also said in one document that P3 has been canceled, and this just says temporarily suspended, so they're changing their argument. Nexon has recently learned that in addition to Choi, two of the departed employees who now work for Iron Mace illicitly took P3 materials shortly before resigning from Nexon. I wonder what these materials would be. So, paragraph 47 and 49. Try and. I wonder if that's at the bottom. Nope. Choi and Park co-founder Iron Mace October. They co-founded Iron Mace in October of 2021. While defendants portray this dispute as being a large corporation and a group of independent developers, defendants have not presented any financial information other than evidence establishing that they are unable to afford the costs of litigation in the United States. Less than a year after its founding, Iron Mace released a demo of the game entitled Darker and Darker on Steam, an online platform operated by Valve, headquartered in Bellevue, Washington, while also relying on servers provided by Amazon to host online gameplay. Players could play the game during alpha tests on Steam from August 19, 2021 to 22, October 28th, November 2nd, 2022, December 16th through 26th, and then again in February 16th through 6th through 16th, 2023. And one quality assurance playtest through September 28th or 23rd through 28th, 2022. Okay, so they held playtests. So the Huang Declaration. So the text elements of Dark and Darker are in English. Furthermore, because standard programming languages are built on the English alphabet, Dark and Darker's source code is also most likely in English. While defendants' brief claims their source code is in Korean, F5, their declarations do not. Defendants heavily. That's kind of damaging. Can't be misspeaking like that. Defendants have heavily marketed Dark and Darker in the United States, promoting the game in English to a large number of followers on Twitter and Discord. Park also went on a media tour on the channels of English-speaking YouTubers to promote the game in the United States. One public relations stunt even directed players to search for physical QR codes under the bench of New York at Central Park. I remember that. Defendants admit that at least one playtest was meant to test basic online gameplay for North American region, and in a QA test instructed players in the United States to use servers nominally designed for the European Union. As a result, players in the United States represented defendants' largest market, accounting for up to 66.34% of players depending on the playtest. So this is why that you don't use. This is why you keep your mouth shut, because they're going to cite Dark and Darker's own numbers and Discord messages and everything in court. People are getting upset at Iron Mace for not talking, but I'm pretty sure I saw in one of their declarations in these pages that Nexon actually cites pretty much all of the announcements for the playtest in these dark documents. So it's in Iron Mace's best interest just to keep their mouth shut. Because Dark and Darker violates Nexon's rights, Nexon sent a DMCA notice to Valve on March 22nd, requesting that Valve take down Dark and Darker. Valve complied on March 25th. See Blackburn Declaration. In response, on April 10th, 2023, Iron Mace filed a preliminary injunction request against Nexon in the Suwon Court District, inter alia, in order enjoining takedown request to Valve. Okay, so April 10th is when Iron Mace filed the preliminary injunction request. They still haven't been granted or denied that preliminary injunction because Nexon waited so long to respond. Sorry, this headset's making my head itchy when it's pressing on the little button in the hat. Ow. Sorry about that, guys. I know it's probably noisy as hell. Yeah, this. Unauthorized downloads. Thanks, Yannick. Yeah, Big Daddy Bubbles. They're doing a lot of obfuscation and misleading statements. Yeah, and Evil Corp, a la Mr. Robot. That's actually pretty cool, Big Daddy. That's stuff to translate uh, code, like English for code, or coding English into other languages would be rad. So that probably is a thing. I would not be surprised. Um, yeah. So, what's up, Bunny HD? Thanks for the love from Hawaii. Is it hot? Is it hot as heck out there as well? I'm up in Oregon and it's like 90 degrees outside right now. Yeah, I honestly don't think it's going to be too long. Um, we should hear back about the case, about the dismissal within the next like 2 weeks, 15 days, for the U.S. case, and then we might hear back about the Korean case on the 19th, so in 8 more days. Um, yeah, back to the. We're almost halfway done. So on April 15th, 2023, Nexon responded to Iron Mace's filing by applying a preliminary injunction. We already know that. Law barring distribution of Dark and Darker. Defendants did not sue in Seoul. The jurisdiction identified in the forum selection caused defendants, so yeah, we know, you've already said that. They agreed. And then they also complained about Seoul Central District Court lacking jurisdiction. I have to look at this. Nexon filed this action on April 14th, 2023, alleging its complaints and defendants act of copyright infringement and misappropriation targeting the United States violate the United States Copyright Act and Defend Trade Secrets Act. On April 20th, Iron Mace sent a DMCA counter notification to Valve requesting that Valve put the game back on Steam, in which it stated Iron Mace consents to the jurisdiction of Western District of Washington. Of course, because they had to. Defendants ran a fifth alpha playtest from April 14th to 19th. While defendants continued to rely on Amazon servers to host the game, they relied on BitTorrent rather than Steam to distribute it. Because Dark and Darker does not comply with Korean video game regulations, defendants geo-blocked. Weird. Oh, it's probably because they used a torrent. In the Suwon litigation, defendants took the position that they created Dark and Darker independently with a blank slate rather than copying and misappropriating from the Project P3. However, defendants refused to produce their source code, and the Suwon court cannot and did not compel them to do so. They produced source code to an independent third party. They did not produce source code to Nexon. They do not have to in Korea. Korea does not have the right to access their private information. A third-party investigator has already accessed it and is comparing the two, and will tell them how it goes. So it seems like Nexon is really, really, really salty that they didn't get a look at P3 source code, or that they didn't get a look at Dark and Darker source code. Defendants continue to express plans to move forward with the release of Dark and Darker in the United States. Of course, the DMCA bars consideration of forum nonconvenience in this case. Before dismissing a case for forum nonconvenience, the district court must first make a choice of law determination. This choice of law analysis is only determinative when the case involves a United States statute requiring the venue in the United States, such as the Jones Act or Federal Employees Liability Act. So, they're trying to say that basically the Trade Secrets Act has to be a federal act. A federal act would bar the dismissal. And because the DMCA was sent because of the Copyright Act and the Trade Secrets Act, that means that it can't be dismissed. However, if the trade secrets aspect is dropped, then that might not hold up. But I don't know. Some of this stuff I'm going to have to talk to a lawyer about. Because I don't know what they're trying to do here, but it seems like they're basically claiming that choice of law determination. Let me 1 second. Choice of law is a procedural stage in the litigation of a case involving the conflict of laws when it is necessary to reconcile the differences between the law of different legal jurisdictions, such as the sovereign states, federal states, the United States, or provinces. Okay. So what they're saying is that they have to do the choice of law determination. What up, FaceAb? So we're going over this document, the newest document, and essentially Nexon's entire argument is that Iron Mace has tried to argue against Seoul as being the best jurisdiction for the case. So they're saying that Iron Mace doesn't want to argue this in Seoul either. They want to do it in another district in Suwon Court. They're also arguing that Nexon argued that the employment contract clauses that Iron Mace is arguing don't apply after termination, and they are arguing that because even though the trade secrets were stolen in Korea, they're being used in the United States and being sold in the United States. But a lot of this stuff is kind of half-truth, and there's a lot of obfuscation and a lot of just pretty much negligence, it seems like, and misspeaking, intentionally omitting omitting facts and information. They're just leaving out entire portions of their statement, and a lot of it so far has been opinion, but opinion that they cite a billion court cases with. So they're citing a lot of precedent, but a lot of the stuff that they're citing the precedent with is opinion based. So that's really up to the judge. In court, anything, at least to the best of my knowledge, what I've been told, anything that is vague and opinion based in court kind of leaves a door open for the judge to form their own opinions on it. So it really comes down to the judge's decision. The more fact-based evidence you have, the better. And right now, Nexon doesn't have a lot of fact-based evidence. They have a lot of opinion-based evidence backed up by court precedent. So it makes their opinions look a little bit more on solid ground. But at the same time, they're also leaving out a lot of information. Nexon is. And Iron Mace is going to fill in all of these gaps. If I can fill in the gaps, you damn well bet that Iron Mace's lawyers are going to fill in the gaps like 10 times better than I ever could. So, in my opinion, while Nexon is making some valid points and has some valid opinions, that stuff might work this way. That's still that doesn't mean that it does, right? That doesn't mean that it's going to work this way again. Just because it has in the past, and it might loosely resemble something that's happening in this case, doesn't mean that it's always a one-to-one uh, issue. But yeah, basically Nexon's making a lot of shit up and leaving out a lot of facts. Wildly stupid. Yeah, I'm trying to be as unbiased as possible. I do have a huge bias towards Iron Mace. Obviously, I called Nexon Evil Corp, but yeah. Thanks for helping with the synopsis, guys. So, uh, good question, Big Daddy Bubbles. Perjury is a very serious allegation. The perjury is a very serious allegation, and it's very hard to prove. It because perjury is a crime of intent. So, just like there's a difference between, uh, murder and manslaughter and stuff like that, there are varying degrees of lying to the court. Now, there is a lying through omission, which is completely legal, which is a lot of what Nexon is doing. There is obfuscation of the truth, which is basically just making everything so confusing that it's hard to find the truth, which is also another tactic that Iron Mace is doing. And then there's just straight up intentionally misleading the court. So when you're intentionally misleading the court, that's perjury, but it's completely um, it's completely up to intent. Like I have to because I could just mistakenly say the sky is green, right? Say we're in court and somebody's suing me over what color I said the sky was. I can mistakenly say the sky is green. Um, but if I intentionally mislead and say, and I know the sky is blue, but I say the sky is green anyway, to intentionally mislead or harm somebody or do something like intentionally harmful or misleading in court, then that's perjury. But you also have to prove that their intent was to lie or mislead, right? So they have to find out the intent. So lying in court isn't always perjury, but perjury always has to have the intent, and lying, it has to have both parts. So I could lie in court just because I'm dumb. Um, so as long as I could prove that I'm dumb and wasn't lying intentionally, it's going to be really hard to charge me with perjury. My non-biased opinion, who's more likely to win in the court case? Um, Neither party. I think that it's going to settle. In which case, I guess Iron Mace or Nexon kind of wins, but it's a win by default. I think that my ultimate opinion is I think that this is going to be um, all wrapped up by November 21st, because that's like the last possible day that of discovery, I think. So November 21st, most like 80% of all cases settle before the end of discovery. So there's literally an 80% chance that this will be done by the end of the that we'll find a settlement before the end of the discovery phase, which would be November 21st, at least for the United States case. But it really depends on what happens in Korea. And if the injunction leans in Iron Mace's favor in Korea, then Iron Mace might decide to stick it out. Yeah, yeah, Wolfram. Everything is based on intent. Like if I turned around really hard, or if I turned around really hard and accidentally like smacked somebody in the stomach unintentionally, that's not assault. But if I turn around and punch somebody in the stomach like intentionally, like trying to hurt them, then that's assault, right? It's all about intent. They never say they. But yeah, let's get back to it. In Zippville, the Ninth Circuit held a court may not dismiss a Jones Act claim on forum nonconvenience ground. The Ninth Circuit relied on Baltimore and Ohio versus Kepner, in which the Supreme Court held that the privileges of venue granted by the legislative body which created the rights of actions under Federal Employee Liability Act, FELA, cannot be frustrated for reasons of convenience or expense. Explain that the outcome of Kepner followed from the fact that FELA contained the very specific venue provision at 1487. The specific venue position in FELA stated that an action may be brought in a district court of the United States in the district court of the residence of the defendant, or in which the case of action. So that's an or, case of which the action arose. So there's two ors right here. That, right? An action may be brought in a district court of the United States in the district court of the residence of the defendant, or in which the cause of the action arose, or in which the defendant shall be doing business. So they're based out of Korea, and their place of residence is in Korea, and the action arose in Korea. The Ninth Circuit extended Kepner to the Jones Act inter alia, because it contained a special venue provision under which jurisdiction shall be under the court of the district in which the defendant's employee resides or in which its principal place is located, which is Korea. As the Jones Act contained a specific venue provision, the Ninth Circuit held forum nonconvenience was unavailable as grounds for dismissal. So what they're trying to say is that because the Copyright Act and Trade Secrets Act, I think more so the Trade Secrets Act, stipulates that you have to try it in the United States. What they're saying is that for them to try the Trade Secrets Act part of this case, it has to be tried in the United States, because the Trade Secrets Act of Korea is different than the very explicit one in the United States. Either that, or they're arguing that the Copyright Act states that it has to be handled in the United States, which I think that would be the more likely of the two, because copyright that's where you're selling the stolen goods, right? So let's say it's not the United States versus National City Lines. Supreme Court construed the Clayton Act, which provided that antitrust suits against corporations may be brought not only in the judicial district whereof it is an inhibitant, but also in any district where it may be found or transacts business. So it can be done in both. As providing a forum nonconvenience analysis, after explaining the venue statute was intended to give antitrust plaintiffs more effective relief than prior law, the court held that for Congress to have broadened the choice of the venue for the reasons which brought about this action, only to have it narrowed again by application of the vague and discretionary power comprehended by forum nonconvenience would have been incongruous, to say the least. Okay. So these paragraphs, when kind of put, or this last page, when kind of put all together, so especially with another page earlier, to me it seems like Iron Mace is claiming that they can't seek the same damages, the laws work differently, and the letter of the law is different, and we're not going to be able to provide as much information in Korea. So, because I know that there's like a cap on damages in Korea that's like, it works differently than the United States. So the way that they award damages, so they might be saying that the damages in Korea might not be substantial enough, and these acts say that we can try in both the U.S. and abroad, because it gives us a better um, opportunity to show our case through evidence and um, fact finding, and also to get a better, like get more adequate damages, right? That suit the case. So it makes sense. So how could Nexon really argue about IM picking Suwon as a court, as them unacknowledging their employment contract? Their suit isn't employment. I really have no idea what Nexon's trying to do with that, to be perfectly honest. They're basically saying their employment contract doesn't exist, but they also cite their employment contract for like half of their complaint is them citing their employment contract. So I don't know. I don't understand that. What up, Fire? Thanks for watching the vids. How many people are watching? I haven't checked my YouTube. Oh, damn. 77 concurrent viewers? Holy snap. Thanks, guys. What's up, Joshua? Wolfram? Pyromaniac? Numpty Kong? That's right. Sucks on. Tequila? No, Tequila, you didn't miss much. I've done a recap since I think you've been in anyway. Oregon, the Pacific Northwest. Can't beat it. I love it. The rivers here are amazing. Let's get back to it. Hellboy, what deets do you need? Just all of them? Yeah, the Pacific Northwest rules. I love it up here. I've lived in California, North Carolina, and here. And Oregon, Washington are by far the best. The Willamette? Yeah, don't swim in downtown Portland unless you want needles in your feet. But the Sandy is super nice. The Columbia is huge. Parts of the Columbia is super nice. And then the Clackamas is really nice too. So here too, Congress has enacted a specific venue provision applicable to a narrow subset of copyright cases involving a foreign defendant who invokes the DMCA counter notification process. In particular, under the DMCA, copyright owner may send a takedown notice to an online service provider requesting the service provider remove allegedly infringing content. So this right here is what I was worried about. This means this is basically almost a veiled. This is saying yes, we can send the DMCA's to foreign businesses, but it also specifically mentions host providers, so AWS. So this is to me saying that they're either already have or probably already are they already have or probably will DMCA AWS to have the game removed from their servers. So if the service provider complies with the takedown notice, the DMCA permits but does not require the alleged infringer to send a putback counter notification to service provider. Of course they don't have to, but if they don't, then the DMCA sticks. If the service provider fails to heed the counter notification and put back the content, the service provider may be held liable to the alleged infringer for a wrongful takedown. Exactly why they have to follow the rules. Unless the copyright owner files a lawsuit seeking injunctive relief within 10 days of the counter notification. Iron Mace did, but they did it in Korea. And they did it in the proper venue. So this is more obfuscation, more misleading information. In granting alleged infringers the privilege of sending counter notifications, Congress requiring an alleged infringer whose address is outside the United States and its counter notification it consents to this jurisdiction or any judicial district in which services provider may be found. In this case, there is no dispute that Iron Mace availed itself of the privileges of sending counter notifications to Valve, and there is no dispute that Valve, which is headquartered in Bellevue, can be found in this district. Okay, under the statutory claims, Nexon are entitled to a venue in this district against defendants. Congress to grant Nexon federal return or federal form to enforce its United States copyright against those who, like Iron Mace, invoke the MCA or consent to jurisdiction in a specified venue, only to have that federal forum taken away by application with a vague and discretionary party comprehended by forum nonconvenience would have been incongruous, to say the least. Citing the same exact thing twice, by its plain terms, the DMCA evinces a congressional judgment that copyright owners should not face uncertainties of litigation, domestic rights overseas, but instead should have the right to a federal forum or to vindicate the United States copyright against foreign defendants. Yeah. So they're basically saying that because the Copyright Exists Acts and they followed the DMCA, the process of the DMCA to a T, that this case should take precedent in the United States because it has to do with the U.S. Copyright Act, a federal act, right? A federal act that does not even exist in Korea. It's a completely different act over there. The way that they handle copyrights is completely different. However, like I said earlier, the copyrights, going after Iron Mace for copyrights in the U.S. makes sense. Going after Iron Mace for trade secrets in the U.S. makes absolutely no fucking sense. Because, like the TV analogy I said earlier, if I stole a TV in Korea and sold it in the United States, I've committed two completely different crimes. I've sold the illegal goods in the United States, but the theft actually happened in Korea. So they need to pick what they want to charge here. This Trade Secrets Act, Iron Mace, even if they are 100% fully in the wrong and found guilty, the act did not happen in the United States. The theft of trade secrets did not happen in the United States. The sale of the stolen goods, the stolen trade secrets, happened in the United States. So it's two completely different things. One's a copyright issue, one's a trade secret issue. Furthermore, Iron Mace brought a preliminary injunction application to Suwon District Court in Korea, asking for an order prohibiting Nexon from requesting a third party such as Valve to take down Dark and Darker from Steam. Mark P. declaration, or Michelle M.P. M. Park. Thus, Iron Mace could have chosen to rely solely on the protection of Korean law and Korean courts. They did. They sent in injunctive relief on April 10th in Korea. Iron Mace did. Rather than doing so, Iron Mace expressly invoked the DMCA counter notification process. They did both. Because they had to. Because Congress has determined that alleged infringers who invoke the DMCA counter notification process are subject to litigation in the venue of judicial district of service provider, so Steam and AWS. This court may not invoke forum nonconvenience so long as the United States copyright law applies. Here, because defendants infringe domestically, United States copyright law applies. So notice how they say the United States copyright law applies, but they don't mention trade secrets at all. They haven't mentioned trade secrets for like 3 pages. United States law applies to determine whether the infringement has occurred, and if so, what remedies are available. Yeah, so it's intent to sell. It's like if I bought a bunch of drugs but I didn't sell them, but I had a scale and a bunch of baggies in my house, you could get arrested for intent to sell, even if you've never sold anything. Yes. So Cody, I have explained that in videos. Um, and that is bad news for Iron Mace, or not? I mean, bad news for Nexon, because their copyright case is very, 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 very flimsy. The copyrights portion of the United States case is extremely flimsy, and I don't think it will hold. Like, it has enough to go to court and be seen by a judge, but I don't think it has anywhere near enough to even make it to trial. Um, and if it does get to trial somehow, a jury will see right through it. If this was strictly a copyright case, slam dunk for Iron Mace. Easy win for Iron Mace. The trade secrets are harder to prove, but like I've been saying, and it seems like they're admitting in this document that the trade secrets don't really apply in the U.S. The trade secret part applies in Korea, and that's where Iron Mace has gone after Nexon. The issue is that Nexon has been filing for both in the United States, and they didn't respond to Iron Mace's lawsuit until after Iron Mace had responded to the DMCA. So Nexon waited until Iron Mace responded to the DMCA and formally agreed in writing to Washington as the venue for the court. And then Nexon said, "Okay, yeah, we'll see you in Korea now, in Korean court as well." But yeah, the the copyright the copyright issue is very weak. I don't know if Iron Mace can get the trade secrets part of this dismissed. They might be able to, um, which would leave them with a pretty easy win on the copyright case. And it might lead to Nexon just dropping that portion of it entirely and focusing on Korea. Because they don't seem to have much. This whole document, we've gone over 18 pages already, and there hasn't been a lot of factual evidence in here at all. It's all been opinion. So defendants cannot establish forum nonconvenience. Even the DMCA venue provision and Iron Mace's consent to it did not preclude a forum nonconvenience analysis. The court should deny defendant's motion for two independent reasons. First, Iron Mace's consent to jurisdiction renders this forum presumptively valid under Atlantic Marine Construction Co. versus United States District Court for Washington, or Western District of Texas. Second, even if the Atlantic Marine presumption did not apply, defendants cannot show the existence of an adequate alternative forum or that the balance of public and private interest strongly favor dismissal. But they do. So this is opinion backed up by precedent, but it's still opinion. There's not really any fact in there. Because it could be very argued that this does affect public and private interest in the United States very heavily. I don't want my taxpayer dollars going. I don't want $100,000 of Washington tax money going to the court just to handle this case, right? So this form is presumptively valid under Atlantic Marine. In Atlantic Marine, the Supreme Court held that where there is bargained for forum selection clause enforcing the bargain for selection protects the parties' legitimate expectations and furthers vital interests in the justice system and must be given controlling weight in all but the most exceptional cases. So this is also can be used against both of them. Against Nexon, and because there's two different forum selection clauses. There's one in the Copyright Act itself, which is a federal act, and then there's also one in the employment contract arguing for Korea. The problem the judge is going to run into is basically what's in the best interest for the courts, what's in the best interest for the people, and what will allow both companies to have a fair shot at as equal of a trial as possible. If that's trying it in the U.S., then they won't dismiss. If they think that they can get all of those things handled over in Korea, then they'll dismiss it and send it to Korea. Um, but it really depends. It's kind of just up to the judge because a lot of this isn't even fact. It's like well thought out opinion backed up by a little bit of evidence through precedent. Here, Iron Mace made a bargain in which it availed itself of the benefits of submitting a DMCA counter notification in exchange for which it stated that it consents to this jurisdiction of Western Washington. Of course, of course, of course. Indeed, the DMCA consent to jurisdiction. Yes. Permissive foreign selection clause. You went over that already. So this is like three or four pages of doublespeak. I feel like I'm reading 1984. My brain's starting to hurt. Uh, yeah, Eric, you're completely right. I'll put it this way. I am a hobbyist game dev working on my own games. I don't even copy my own code because by the time that I've progressed far enough, I've learned better ways to do it. Like, it doesn't make sense. Like, it's an iterative process, right? And I started making an MMO or a multiplayer online RPG a while back. That was basically New World Ultima Online, or Ultima Online, but with action combat. Yeah, easiest way to say it. Um, and then I transitioned that into the game I'm working on now, which is like Dark and Darker meets New World with a little bit of Ultima flavor, but it's a lot smaller in scope, and they share a lot of the same mechanics, a lot of the same assets, a lot of the same everything. But now I'm better at doing the code. I'm better at doing blueprints in Unreal. So I didn't even use the old game file to like jumpstart my progress because it was quicker and more efficient for me to just take what worked and rewrite it from the beginning and get rid of the excess code, right? Get rid of the excess that I didn't really need and the redundancies. But yeah, you don't just copy paste stuff like that. And yeah, Bubbles, you're right. There's a lot of infuriating comments going on with this, and a lot of doublespeak. They're just saying the same thing in like 20 different ways, citing different court cases, loosely citing different court cases to try to get their point across, but they're not really saying anything new. So courts have repeatedly held that where a plaintiff sues in a jurisdiction designed in a permissive forum selection clause, a defendant seeking to transfer a case outside the permitted forum must meet the Atlantic Marine Standard to defeat the plaintiff's choice. Carl W. Schmidt and Associates, Inc. versus Action Environmental Solutions, LLC. Here, Congress have alleged infringers an expeditious procedure to counteract the DMCA. Takedown notice, namely a privilege of DMCA. Okay, cool. Change for this privilege, which results in a service provider putting the content back up unless the copyright owner promptly files a lawsuit seeking injunctive relief, which Nexon did. However, Iron Mace did as well. No mention of trade secrets again. Okay. Like the Atlantic Marine a bunch. But the forum selection clause the defendants rely on. So here's why ours. So Nexon's basically saying here's why ours works because of these clauses in the Copyright Act. But here's why the clauses in the employment document don't hold any water. So this is that section. So relying on forum selection clauses that call for litigation in sole Central District Court, defendants argue Atlantic Marine presumptively requires Nexon to litigate its United States claims in pending proceedings initiated by Iron Mace in Suwon District Court at 10 because no one bargained for litigation in Suwon Court. Defendants' argument relying on Atlantic Marine are frivolous. So they're both fighting the same court or the same ruling in Atlantic Marine. Which is kind of odd. Escape past this deficiency by claiming the parties signed a Korean forum selection clause, but no party to this suit agreed to any such clause with any other party. 10. So what they're saying is that Iron Mace as a company didn't sign the documentation. And Nexon as a company didn't sign the documentation. The only people who actually signed it were Mr. Park and Mr. Choi, so they're the only ones that are held accountable to that document. Which is just not true. At least that's what it seems like. No party to this suit agreed to any such clause with any other party. Either that or they're saying that the clause no longer exists. The court therefore must reject defendants' request to apply Atlantic Marine in their favor. Even if defendants were seeking to litigate in sole, their argument still fails because the clause on which they rely on do not cover the disputes based on tortuous conduct or conduct occurring after Choi and Park employment. Defendants' contrary argument relies on translating the Korean words, can't read that, into English related to this agreement, but these Korean words could also fairly be translated as arising out of this agreement, regarding this agreement, in connection with this agreement, and other formulations. Defendants cherry-picked the related to translation because related to has been broadly construed in their favor in the United States case law. But defendants offer no principled reason for selecting related to instead of arising out of or any other possible translation. So they're Nexon is using unclear language to argue the fact that Iron Mace used unclear translations. They're using opinion. They're obfuscating the truth. There's obviously some neglect in here and just withholding information. And now they're just arguing semantics, which is a lot of what law is, but you don't expect it to happen this early on. Nexon is a bunch of dicks. By contrast, Professor Stuck explains how the Korean word would be understood by Korean speakers and demonstrates that they do not cover this dispute. Furthermore, the Korean Supreme Court has authoritatively construed contractual agreements specifying a Korean court as exclusive jurisdiction for dispute, reflecting only an agreement to which the Korean within Korea will hear a dispute, assuming the litigation is filed in Korea in the first place. It is. Such clauses do not reflect an agreement that litigation cannot be brought outside of Korea when another country's court have jurisdiction over the dispute. Such clauses do not reflect an agreement that litigation cannot be brought outside. So, are they saying that the clause they wrote in their own contract isn't able to be upheld? So they have a bad faith clause in their contract. To To me, this seems like they're admitting to having a bad faith clause in their contract. This this part of the paragraph seems like they're admitting that there's a clause in the contract that they wrote with a lawyer that is in bad faith. Interesting. Because the parties are presumed to rely. Okay, so why? Because the parties are presumed to rely on the existing body of law in entering into the agreement. That's exactly what I said. The courts must follow the law here. Schrodinger versus United States. That's exactly what I said in my last live stream, and exactly what I said in one of my last, not my last video, but like 1 or 2 videos ago. That when I went over this when I went over the documentation and the employment contracts. So essentially, what's happening is Nexon is taking laws that already they exist and supersede the contract. They exist in Korea and supersede this contract, meaning that the clauses that they're writing into their contract are non-enforceable and are placed there in bad faith. And what they're doing is they're arguing essentially that the contract they wrote and had the employees signed and they signed themselves is a bad faith argument. It's a bad faith contract. So if I'm Iron Mace's lawyer, I point to this exact paragraph and I go, this entire contract is void. It was written in bad faith. If they're saying that this contract, if these clauses aren't enforceable because Nexon wrote them in bad faith, which they agreed to basically admit to here, for not blatantly, but it's like pretty obvious that they're writing bad faith arguments into their contracts, which are already protected under federal law in Korea and in the United States. So, holding federal courts give effect to the parties' intentions as ascertained from terms themselves. Queen City Farms Incorporated versus Central National Institution of College Omaha? I don't know. It's all abbreviated. Holding that where there is a prior judicial construction of words in a contract, it is presumed that the construction is intended by the parties. Look to general principles for interpreting contracts. Furthermore, to avail itself in the form selection clause in Choi and Park's employment-related agreements with Nexon, Iron Mace's allegedly wrongful conduct must have some connection to the agreements themselves, rather than Iron Mace simply having a connection to signatories to those agreements. They just argued the exact opposite. So they just argued that Iron Mace didn't sign these Iron Mace and Nexon as companies did not sign these contracts, that Mr. Choi and Mr. Park did. But now what they're saying is that furthermore, to avail itself of the forum selection clause in Mr. Choi and Park's employment-related agreements with Nexon, Iron Mace's allegedly wrongful conduct must have some connection to the agreements themselves, rather than Iron Mace simply having a connection to signatories to those agreements. So now what they're applying is that Iron Mace is Choi and Park, and if the contract is cited, that means that Iron Mace itself, via Choi and Park, are to be upheld by this agreement, because Mr. Choi and Mr. Park are Iron Mace. But 4 paragraphs ago, they argued the exact opposite. Oh shit. I'm sorry to hear that, Bubbles. That sucks. Sorry, I'm reading through chat. Yeah, some interesting stuff in there, Eric. Mitch, what up, dude? Thanks for the super. Thanks for joining the live stream. Also, when are we gonna play some Warzone or something? When are you gonna come over? Everybody, this is Mitch, my buddy. I've known him for like 20 years. He's in chat right now. What up, dude? You gotta come over. We gotta go grab a drink at Clubhouse. Um, so yeah, James. Basically, Iron Mace's argued. Their entire argument is basically the employment contract is null and void. So the clause that Iron Mace is trying to get the case dismissed with is non-existent anymore. They're arguing that the contract doesn't exist. They argued that the if the contract does exist, it's with Mr. Choi and Mr. Park, not between Nexon and Iron Mace. So Nexon and Iron Mace can fight each other out in whatever court they decide, and Iron Mace already agreed to fight it out in Washington. However, they also just argued that complete opposite side. So they're arguing both sides of the fence, and their entire argument so far comes up to Iron Mace used the wrong translation for one sentence. The contract doesn't exist, and that copyright law in the United States and in Korea supersedes any contractual obligation that might have happened through employment. So yeah, if the contract is over, that means that all those IP clauses in those contracts, all the non-compete clauses in those contracts, all that are null and void too. You can't just invalidate portions of a clause. Once you start invalidating clauses in a contract, it's like imagine it like a negative point, right? Like your driver's license. So you can only get like 3 points on your driver's license, and like speeding is 1 point, running a red light is 1 point, and getting into an accident that's your fault is a point or whatever, and then they take your driver's license away or suspend it. It's kind of the same thing in contract law. What ends up happening is once you start invalidating clauses, there comes a point there comes a point where, okay, this clause not being valid anymore might have just been a mistake. This clause and this clause both not being valid anymore is suspicious, and then okay, well, you have half of your contract is invalid now, and none of those clauses were written in good faith, which calls into question the veracity of the agreement as a whole, because if the person who created the contract with including bad faith arguments intentionally, that means that's actually illegal. You can't create a contract like I can't create a contract that says Joe is going to give me $50 or he kills himself, and then we both sign it, and then Joe doesn't give me $50. Like, it's not enforceable because I can't. The contract was written in bad faith because it makes it so Joe has to harm himself, right? You can't bad faith contracts get thrown out all the time. It's why a lot of companies kind of have been trying to force arbitration clauses into their employment contracts, so that you have to arbitrate out of court, because a lot of the employment contract stuff It's already covered under employment law. Like federal employment laws in the United States cover a lot of that stuff that would be in your employment contract, and a lot of that employment law supersedes the contract. So the contracts themselves are actually just there to mislead employees and convince them that they have to abide by laws that aren't actually relevant or legal. Yeah, I have. Yeah, Nexon's argument's kind of bunk. Yeah, it's this contract is shitty, and it probably won't hold up. I honestly can see that the contract. Unfortunately, I think the dismissal probably won't go through just by reading this. I think what's most likely going to happen is that contract is going to get thrown up. They're just going to tear that whole contract up. But that might call into question the trade secrets part of the case, because that the trade secrets part of the case rely very heavily on the fact that um, under that contract they vaguely outline basically anything that you do while employed at Nexon becomes Nexon property, right? Whether you sign it over or not. Um, what you do while you're on the clock for Nexon, we own. What you do, and if you're salaried, that means forever, you know. So but they have a no faith they could argue that the faith is a no faith contract and get the contract thrown out, which basically waives Nexon's rights to steal all of their IP and their ideas. Um, but yeah, we'll see how this plays out. Yeah, so right here, this sentence. Because Iron Mace was not even formed until after the termination of Choi and Park's employment, Iron Mace infringing and misappropriation lacks the requisite relationship to the performance of the employer-related agreement themselves. Similarly, under Korean law, Iron Mace has no right to enforce the agreement between or agreements because it is a non-party. So they're basically saying Iron Mace isn't a person; it didn't sign these agreements and isn't related to these agreements. However, Iron Mace as a company can therefore say if we're not upheld to these standards, then the ideas that Iron Mace had while our employees were working for Nexon aren't yours. Suck it. All of this stuff is ours. Iron Mace didn't steal anything. If you want to go after somebody for breaking trade secret laws, you have to go after the person who broke it. So Iron Mace isn't held liable or responsible because it's a non-party. So they're arguing both sides of the fence here. You cannot do that. You can't argue like uh, Iron Mace is a person, but it's not a person. You can't like either you want to have it tried as a person or not. And are Mr. Choi are Mr. Choi, Terrence Park, and Iron Mace all so closely related that they're all constitute as one legal entity in this circumstance, or are they separate individuals, which you would have to try separately? In which case, Iron Mace didn't violate any trade secrets laws because Iron Mace the business never worked for Nexon or stole anything from Nexon. It doesn't make any sense. Like this is all just stall tactics. It's stall tactics and doublespeak. It's insane. Moreover, defendants themselves took the position that the forum and the funny thing is I kind of called this in one of my last videos. I think it was like 2 videos ago where I go over the employment agreement. I already knew this was going to happen. I called this 2 or 3 weeks ago. Moreover, defendants themselves took the position that the forum selection clause do not cover the dispute and Park declaration. Iron Mace initiated Korean proceedings in Suwon Court District instead of Seoul. District lacks jurisdiction over the party. So, yeah, Iron Mace wanted to have their lawsuit against Nexon in Suwon, and that's where they started the lawsuit in Suwon. But they did that because they're suing them as Iron Mace. They're having the the entity of Iron Mace is suing Nexon and Suwon. It's not Mr. Park and Mr. Choi, it's the entity of Iron Mace. That is suing and Suwon. And like they just said in this, Iron Mace apparently never signed the contract. So which is it? Who is who? Like, make up your damn mind, Nexon. You can't argue both. So Iron Mace suing and Suwon has no bearing on the case, in my opinion. District Court lost jurisdiction over parties to dispute Korean copyright trade secret law because Iron Mace is based in Suwon. So they went to the correct venue. And they would have nothing to do with the employment agreements like Iron or Nexon just stated. Defendant's reasonable practice. Both Iron Mace and Nexon can't argue both sides. It doesn't work like that. Nexon's doing it far more, but they have to pick one. Either Iron Mace is a person or it's not a person. And Iron Mace, Mr. Choi, and Park are all connected or they're not connected. They have to pick one. Can't play both. Will be adopted and enforced by the court. Finally, even if the position defendants are currently taking in this court were correct, it would mean that defendants actively misled Suwon District when taking the opposite position there, giving defendants an unfair advantage of litigating in their preferred forum. Because this court, so what they're saying is that if Iron Mace wants to be counted as a person, it should have sued Nexon in Seoul according to that contract. Which is fair enough to say. I mean, I'll give them that. If Mr. Park and Mr. Choi want to have all of them so closely interconnected that the contract binds all three, to get the U.S. case dismissed, then they should have had their lawsuit in Seoul as directed by the contract. But they didn't. They went to Suwon instead. So that's kind of damaging to Iron Mace. That's like the one damaging thing in Iron Mace's going against Iron Mace so far in 22 pages. Oh, snap. It's already 6:42. I got to head to the store. So I'm going to go to the store real quick and I'll probably pop back in like half an hour, 45 minutes and finish this document. I'm going to leave off on defendants cannot establish traditional forum nonconvenience. So I'm going to pop back in like half an hour, and I'll finish the stream up and read at least the rest of this document. But yeah, sorry guys, I got to cut it short. I got to cut it short. I will finish this when I get back. I have to run to the grocery store. We have people coming over in like half an hour, and we don't have any food or snacks or anything. Early access, my opinion, is that we're going to know more. I won't guarantee it or can't say it's coming out for a fact, but I think we will at least have a better idea of when early access will be by July 19th to July 27th, like 26th. So yeah, we'll know about what happens in Korea by July 19th or 20th, and then we'll know what happens with the injunction and dismissal in the United States by July 26th, 27th. So we don't know if the injunction, so the Korean date of July 19th either is the last day of the investigation or it's the preliminary injunction hearing. This document says that it's the end of the investigation. So that would put the preliminary injunction hearing in Korea back another 30 days. So that would mean that the injunction hearing in Korea would actually be happening around August. How many days are there in July? 31. So it'd be August 18th. So yeah, August 18th is So on or before August 18th, we should have the preliminary hearing for the injunction in Korea. That's where they make the final, not the final, they make the first injunction decision, and then they go through the appeals process twice, and then they make a final declaration with a panel of judges. Yeah, so that's what I've been reading too, is that the investigation has to be concluded on the 19th, and then they have 30 days to submit the conclusive report and evidence, and then they have to make that decision. The judges have to make a decision within a certain amount of days. So we'll know more in Korea by like the 18th or 19th of next month. But yeah, I gotta head out. My girlfriend is waiting. I will be back in like half an hour, an hour. All right. Peace. Thanks for stopping by.